Hi, it's Mike DelSignore. In today's video, I want to talk about what happens if you're arrested for OUI and your case is going to be heard in the Salem District Court. OUI cases it's easy to get charged with OUI. An officer needs very little evidence to arrest somebody, yank them off the road. It's called probable cause. But to convict somebody of an OUI, you need proof beyond a reasonable doubt. So there's a much higher standard to be found guilty in court versus what it took for an officer to put you through this process, basically, to arrest you and make you go to court. So keep in mind there's a light at the end of the tunnel. Let's say you refused a breath test. They don't have the evidence of your BAC. So now the case is going to come down to the officer's observations about your driving, how you interacted with them. The officer will say smell of alcohol, strong, weak, moderate. Might say you had slurred speech or was sluggish. Those are kind of typical observations. They'll note how you got out of the car. And they'll mention in the report how you performed on the so-called field sobriety test, which they say helps them determine whether you're under the influence of alcohol. But as you know, there are a lot of reasons why maybe you didn't balance perfectly on the one-leg stand. Maybe you didn't follow all the instructions on the 9-step. You were nervous, it was on the side of the road, and these tests were unfamiliar instructions to you. So there's a lot of reasons why someone might not be under the influence of alcohol, but still might not do well on these tests. So we can get your medical records to show any injury. Potentially you could testify to explain you were tired, things like that. But in a lot of cases, we don't even need you to testify. I can do it through cross-examination of the officer. So keep in mind, these are winnable cases, more difficult to be found guilty than to be arrested. If you took a breath test, you only lost your license for 30 days, so you can get your full license back after 30 days. The breath test doesn't automatically come into evidence. There's ways that I can get the results excluded from evidence, so it's not known by a judge or jury considering your case. So we can make it, turn it into a subjective case. So there might be a test result, but don't assume that's automatically going to be presented to the judge or the jury, or that's even reliable indication of what your blood alcohol was. So I've won a lot of cases with breath test results. I'm a member of the National DUI College. I've attended seminars. I've spoken at seminars. I've been doing this for my entire life, and I'll be able to explain to you when you call different ways that the breath test might be able to be excluded from evidence. So what's the court process like ahead? You're going to be arraigned. If you were just arrested over the weekend, you'll be arraigned. You'll get a further date to come back. On a first OUI offense, you're not going to be held on any bail. You'll be released on your promise to appear. Even if it's your second offense, typically there's not going to be any bail request. In some cases, if there's an accident, if there's something egregious about the case, that could be an alcohol-free condition. But for most people, first OUI, you're going to be released on your promise to appear without any conditions. The next court date will be a pretrial. Not much will happen at the pretrial. We'll get additional evidence that they plan to use at the trial. And it'll help us decide whether we want a trial or want to work the case out. It's one of the frustrating things. It does take a lot longer to get the evidence than people expect. Usually the videos take 6 to 8 weeks to get. Now they probably should have them. They probably should have them much quicker. It's not really anything the government is doing intentionally. They just don't really have the support to keep up with all the discovery requests, basically. So there's a little bit of a downtime in the case, but we'll get all the evidence, be able to decide if there are any motions, legal issues that we need to explore before putting the case on for trial. Some cases we might want to say, well, the stop wasn't valid. Why did the officer even stop you? So we can challenge that. It's called a motion to suppress. We might say, well, maybe the stop was valid, but why did I get a ticket? It should have been let go. There wasn't really a basis to continue this, to make me do field sobriety tests. That's a challenge to the exit order. It might be a statement you made. Potentially you admitted to how much you had to drink without being read Miranda rights. We might want to exclude that from evidence by doing a motion to suppress. So there's different legal defenses to the case, legal issues that we might explore prior to trial. Sometimes we'll do a breath test motion to exclude the test prior to trial. Then the final date of the case will be a trial. It's either in front of a judge or jury, and that's when the court decides or jury decides whether the government's met its burden of proof beyond a reasonable doubt. But I'll be there with you every step of the way to explain the process, to help make this understandable, to help you move forward with your life, make the best decision possible. So feel free to call, text anytime, 781-686-5924. My name's Mike DelSignore. My passion is helping people get their lives back together after an OUI case, and I'm here to help you.